Patriots, the Oregon Supreme Court just heard oral arguments in what could be the biggest gun rights case in Oregon history. And the justices asked some brutal questions that have state attorneys sweating. We're talking about Oregon Measure 114, the tyrannical law that bans standard capacity magazines over 10 rounds and requires a government permit before you can buy any firearm. A lower court judge struck down this entire law as unconstitutional. But the Oregon Court of Appeals reversed that decision. Now the Oregon Supreme Court, packed with Democrat-appointed judges, will decide the fate of gun rights in Oregon. Before we break down the oral arguments and what the justices asked, smash that subscribe button. We're covering the case that could free gun owners in Oregon. Let's get to 850,000 subscribers. Let's dive into what happened at oral arguments. Let me explain what Oregon Measure 114 actually does, because this is one of the most oppressive gun control laws in America. Measure 114 was passed by Oregon voters in 2022 narrowly, and it does two terrible things. First, permit-to-purchase system. Before you can buy any firearm in Oregon, you must obtain a government-issued permit complete. Mandatory firearms training submit to fingerprinting. And photos pay fees to the government. Wait for government approval. This is a issue system where the government can delay or deny your ability to exercise a constitutional right. SHREDS magazine banned. Measure 114 bans the sale, purchase, transfer, and possession of any magazine holding more than 10 rounds. That's right, not just future magazines, but magazines you already own. This is confiscation-level tyranny. If you own standard 15-round, 17-round, or 30-round magazines, Oregon says you're now a criminal unless you turn them in or destroy them. This law targets the most common magazines in America. The majority of handguns come with magazines holding more than 10 rounds from the factory. Oregon gun owners immediately recognized this as unconstitutional tyranny and fought back. The lower court VICT or WITHA case, Arnold v. Kotek, was filed in Oregon State Court challenging Measure 114 under the Oregon State Constitution. This is important. The case is based on Oregon's Constitution, not the federal Second Amendment. This gives Oregon courts different standards to apply. The case went before Judge Robert Ratio, and after reviewing extensive evidence, expert testimony, and legal arguments, Judge Ratio issued a powerful ruling. He struck down Measure 114 in its entirety with a permanent injunction. Judge Ratio found that the magazine ban violates the Oregon Constitution. The permit system is an unconstitutional burden on rights. The claimed public safety benefits are overblown and not supported by evidence. Law unduly frustrates the right to armed self-defense. Was a complete victory for gun rights. But Oregon's anti-gun government wasn't going to accept defeat. The Court of Appeals, DSSE de Oregon, appealed to the Oregon Court of Appeals, asking them to reverse Judge Ratio's permanent injunction. And the Court of Appeals, in a unanimous decision, sided with the state. They overturned Judge Ratio's injunction and ruled that Measure 114 is facially valid and constitutional. The Court of Appeals basically said, the permit system is a reasonable contemporary response to public safety concerns. The magazine ban addresses threats from advancing technology. Therefore, both are constitutional. They completely ignored the extensive factual findings that Judge Ratio made. They dismissed expert testimony. They rubber-stamped Oregon's tyranny. The Court of Appeals applied what many legal experts believe was the wrong constitutional test. Instead of asking whether the law unduly frustrates the right to self-defense, they asked whether it was reasonable. This gave Oregon a much easier standard to meet. Gun rights advocates immediately appealed to the Oregon Supreme Court. Oregon Supreme Court oral arguments. Now we get to the exciting part, the oral arguments before the Oregon Supreme Court. The Oregon Supreme Court is packed with judges appointed by Democrat governors. The deck is stacked against gun rights. But something interesting happened during oral arguments. The justices asked some very tough questions to the state. On the magazine ban, the petitioner's gun rights side argued that the Court of Appeals applied the wrong test. They emphasized that Oregon law doesn't let the state just call something reasonable and be done with it. The correct question is, does the law unduly frustrate the right to armed self-defense? Several justices pressed this point, questioning whether Measure 114 merely regulates magazines or whether it effectively bans common loud arms. And here's where it got really interesting. One justice asked the state directly, what's the limiting principle? If you can ban magazines over 10 rounds, can you ban magazines over 8 rounds? 5 rounds? 2 rounds? What stops you from setting an arbitrary capacity floor? This is a killer question. If there's no limiting principle, then Oregon could ban all magazines and effectively ban all modern firearms. The state struggled to answer. They couldn't identify any logical stopping point. They essentially admitted their position has no constitutional boundaries. On the permit system, the justices raised even more pointed concerns about the permit-to-purchase requirement. Several justices questioned, can Oregon require training or government approval before exercising a fundamental right absent some genuine threat or concern? One judge made a powerful analogy. This is like forcing someone to take a class before exercising free speech. Think about that. Imagine if Oregon required you to take a government-approved training course, submit fingerprints and photos, pay fees, wait for government permission before you could write a newspaper article or attend a protest. That would obviously violate the First Amendment. So why is it okay for gun rights? The justices seemed genuinely skeptical about whether the permit system crosses the line from regulation into unconstitutional prior restraint. The constitutional test DEBAT. Understanding the constitutional test is critical to this case. Oregon applies a two-phase test under Article 1, Section 27 of the Oregon Constitution. Phase 1. Does the Oregon Constitution even apply? Are magazines arms? Oregon argues magazines aren't arms and therefore have no protection. The plaintiffs argue correctly that magazines are obviously arms. They're instruments that facilitate armed self-defense. Phase 2. If the Constitution applies, does the law create an undue burden on the right to armed self-defense? This is where Oregon tried to shift the test. They want courts to ask, is this regulation reasonable? But the plaintiffs argue the test should be, does this unduly frustrate the right? There's a huge difference. Reasonable is a low bar. Unduly frustrates is a much higher bar that protects rights. The Court of Appeals used the wrong test, and the Supreme Court needs to correct this. What the questions man now? You can never predict how judges will rule based solely on oral argument questions. Judges often play devil's advocate or ask tough questions to both sides. But the questions here reveal some important things. Skepticism about the permit system. Multiple justices seemed concerned that requiring government training and approval before exercising a right is a prior restraint, which is generally unconstitutional. Concern about limiting principles. The justices recognized that if Oregon can ban 11-round magazines, it could ban any capacity. This is a slippery slope toward total disarmament. Focus on undue burden test. The justices seemed interested in whether the Court of Appeals applied the correct constitutional standard. These are good signs for gun rights. But we have to be realistic. The reality Democrat, Akuje, mishears the harsh reality. The Oregon Supreme Court is dominated by judges appointed by Democrat governors. These judges likely have personal views that favor gun control. They probably support Measure 114 on a policy level. So even though they ask tough questions, they might still find a way to uphold the law. Judges are human. They have biases. And Democrat-appointed judges have a track record of bending over backwards to uphold gun control laws. The hope is that these justices will follow legal principles over political preferences. that they'll recognize the Constitution protects gun rights even if they personally don't like guns. At a minimum, the Supreme Court might remand the case back to the Court of Appeals and tell them to apply the correct constitutional test. That would at least give gun rights advocates another chance to prove the law is unconstitutional. If Oregon's Supreme Court rules against gun-rights TEDs, but what if the Oregon Supreme Court upholds Measure 114? There's still hope. The case could go to the United States Supreme Court. Even though this case was brought under the Oregon Constitution, it also implicates the federal Second Amendment. The U.S. Supreme Court could review whether Measure 114 violates the Second Amendment under the Brink standard. In fact, taking this case to the U.S. Supreme Court might be the better strategy. The federal Supreme Court has a 6-3 conservative majority that takes gun rights seriously. The Brink decision already established that gun regulations must be consistent with historical tradition. Oregon's permit system and magazine ban would have a hard time surviving that test. So even if Oregon's Supreme Court fails, this fight isn't over. What gun owners should do if you're an Oregon gun owner? Here's what you need to do. First, stay informed. Follow this case closely. The Oregon Supreme Court could rule any day. Second, continue complying with current law while the case is pending. Don't give prosecutors ammunition to use against you. Third, support the legal organizations fighting this battle. They need resources to potentially take this to the U.S. Supreme Court. Fourth, organize politically. Vote out politicians who support Measure 114. Make gun rights a voting issue. Fifth, prepare for multiple scenarios. If the law is struck down, know your rights. If it's upheld, prepare for the next legal battle. Sixth, spread awareness. Most Oregonians don't even know this case is happening. All right, Patriots, that's the complete breakdown of the Oregon Measure 114 oral arguments before the Oregon Supreme Court. Let me summarize. Measure 114 bans magazines over 10 rounds and requires permits to purchase. Lower court judge struck it down. Court of Appeals reversed. Oregon Supreme Court heard oral arguments. Justices asked TOUGH questions about limiting principles and prior restraint. Court packed with Democrat judges, outcome uncertain. Could still go to U.S. Supreme Court if Oregon upholds. The next few weeks or months are critical. The Oregon Supreme Court's decision will determine whether millions of Oregon gun owners can exercise their constitutional rights or become criminals for owning standard firearms and magazines. If you found this valuable, smash that like button. Share with every Oregon gun owner. Subscribe for updates when the court rules. Comment, do you think Oregon Supreme Court will strike down Measure 114? Or will this have to go to the U.S. Supreme Court? Until next time, stay armed, stay free, and never stop fighting tyranny at every level of government. God bless Oregon gun owners, and God bless the Second Amendment.